Hey everyone, welcome. Today's explainer's zeroing in on a massive shift that literally every modern business leader needs on their radar right now. We're talking about India's Digital Personal Data Protection Act, or the DPDP Act 2023. And don't worry, we are not just going to read dry legal jargon today. We are actually unpacking how you can turn a pretty complex mandate into a streamlined, secure reality for your organization. There's a quote that really hits the nail on the head. Personal data is the lifeblood of your business, but protecting it is a legal necessity. And honestly, that right there sets the stage for our entire conversation. I mean, we all know that data drives modern business, right? It helps us understand our customers, it refines our products, and it scales our operations. But those days of just collecting data with zero oversight, yeah, those are officially over. Ignoring the protection of this lifeblood is no longer just a bad idea, it's a hard, non-negotiable legal requirement. So you might be asking the single most common question we hear, which is, does this DPDP Act actually apply to my business if I don't even have a physical office in India? Well, the short answer is a resounding yes. If you are collecting or processing the personal data of individuals who are within India, you are generally subject to this act. It doesn't matter where your global headquarters happens to be pinned on a map. Simply put, if their data is in your system, their laws apply to you. Okay, to give you a complete picture today, here's our agenda. Number 1, understanding the DPDP Act 2023. Number 2, the hidden compliance risks. Number 3, the 7-step DPDP roadmap. Number 4, specialized compliance solutions. And finally, number 5, the benefits of compliance. It's a very clear, logical path from understanding the problem to actually implementing the solution. All right, let's jump right into Section 1, understanding the DPDP Act 2023. So, strictly speaking, the Digital Personal Data Protection Act governs the collection, use, and disclosure of personal data by organizations. But let's go a bit beyond that textbook definition. At its core, this law is demanding absolute clarity. It requires that user consent is crystal clear and that your actual purpose for collecting the data is explicitly defined up front. Now, the real challenge for businesses is figuring out how to translate all those heavy, complex legal clauses into a practical, everyday security framework. It's all about making sure your organization is fully prepped to confidently handle any regulatory inquiry that comes your way. Moving on to Section 2, the hidden compliance risks. Look, what you don't know absolutely can hurt you here. Take silent data collection, for example. This is a massive vulnerability for a lot of companies. This happens when you're gathering user information without getting clear consent or having a reasonable purpose. Just think about those legacy forms that have been sitting on your website for the last 5 years, or background cookies that track user behavior like a digital shadow. Under the DPDP Act, that silent collection is a huge red flag. And on the flip side, there's the risk of failing to provide data portability. Basically, if a user asks for their data, or they exercise their right to be forgotten, and your system just ignores them because it's not built to handle the request, that's a major compliance failure. And then there's arguably one of the scariest parts of modern business operations, vicarious liability. You could have an absolute ironclad digital fortress inside your own four walls. But what about your partners? If you're sharing data with a third-party vendor and they experience a data breach, guess what? Under these DPDP guidelines, you are often the one held legally responsible. It's kind of like lending your car to a friend who ends up crashing it. You are the one who still has to pay the insurance premium. A weak link in your vendor's security literally means you pay the ultimate price. You just can't outsource your risk anymore. We really need to understand what happens if you get this wrong, because the cost of non-compliance is definitely not just a slap on the wrist. We are talking about stiff financial penalties that can easily reach into the millions of dollars. Think of the massive fines we've seen handed out under European privacy laws. It's that level of serious. But beyond just the fines, you have to consider the severe consumer backlash. In today's hyper-privacy-conscious market, even a single valid complaint can trigger public regulatory investigations, and that leads to irreparable reputation loss. These are very tangible, potentially business-ending threats. Okay, let's pivot to the solution. Section 3, the 7-step DPDP roadmap. This roadmap is how you turn complex compliance into practical security. Building that secure foundation starts with Step 1, awareness and scoping. This is where your leadership gets educated on their obligations, and you define the exact data boundaries of your business. Step 2 is data inventory and mapping. You literally have to know exactly where personal data, or PII, enters, stays, and eventually leaves your organization. Then, Step 3 is a gap assessment, where you compare your current state against the DPDP's data protection obligations. And that leads to Step 4, remediation and hardening. This is the hands-on part where you actually implement technical safeguards like strong encryption and robust access controls to fix the gaps you just found. From there, we move into the second phase. Step 5 is policy development. And no, this is not about just copy-pasting something from the internet. It is about drafting custom privacy policies and internal standard operating procedures that are tailored to your actual data flow. Step 6 is employee training. Let's be honest, your people are usually your first line of defense. So specialized workshops ensure your team knows the absolute do's and don'ts of daily data handling. And finally, step 7 is the final compliance audit. This is a comprehensive review to officially certify that your business is fully DPDP ready. That brings us to section 4, specialized compliance solutions. So a central requirement of this new law introduces a very critical role, the Data Protection Officer, or DPO. This is an appointed expert who oversees your organization's privacy obligations and makes sure everything stays strictly aligned with the regulations. But here is the really great part for growing businesses. You don't necessarily have to go out and hire a full-time, expensive executive for this. You can actually utilize DPO as a service. This allows you to outsource this highly specialized expertise to dedicated consultants who just handle it all for you. Drilling down just a bit further, maintaining your compliance posture requires a specific suite of services. First up, a consent and purpose audit is absolutely crucial. You have to ensure every single piece of data you collect has a rock-solid legal basis. We already talked about DPO support, but crucially, you also need to prep for data breach management. Look, if the worst does happen, the DPDP Act has extremely strict mandatory reporting requirements. You need established 72-hour notification protocols ready to roll, and specialized services can help you build and execute those protocols flawlessly. When you're looking for compliance solutions, taking a strategic hybrid approach is definitely your best bet. On one side of the coin, you need local expertise. You need a deep, practical understanding of the specific nuances baked into India's DPDP Act. But on the flip side, you also want global privacy standards. The framework you build today for India should really act as a scalable foundation for international standards later on, like GDPR in Europe or CCPA in California. Merging that local legal knowledge with a global technical architecture is exactly the edge that specialized services can provide. Finally, let's hit Section 5, the benefits of compliance. Because when you do this right, the advantages are just incredibly powerful. First off, you get to operate with total legal confidence, freeing you from that constant nagging anxiety of lawsuits or government audits. Second, you actively build customer loyalty. When you show users that you deeply value their privacy, compliance stops being a legal checklist and transforms into a massive marketing advantage. Third, like we just touched on, it enables seamless global expansion. And finally, when your data is properly organized and mapped, it minimizes the blast radius of any potential incident. That dramatically reduces the financial and operational costs if a breach ever does occur. I absolutely love the mindset behind this approach. We don't just find the problems, we stop the risks, stop guessing, and start securing. It's a perfect summary of what your mindset shift needs to be. Compliance should never act as a bottleneck that stops your business growth. By implementing a clear to-do list and simplifying the whole process, security actually becomes a natural, seamless part of your business evolution, rather than just some frantic, stressful reaction to a problem. So, as we wrap up today's explainer, I want to leave you with a provocative question to chew on and maybe take back to your teams. Is your organization truly building a culture of privacy by design, or are you kind of just waiting around for a regulatory wake-up call? The DPDP Act 2023 is here. The roadmap to get compliant is totally clear. The only question left is whether you're going to be proactive or reactive. Thank you so much for joining me today to unpack this crucial topic, and I will see you in the next explainer.